Thank you very much, my Lord. My Lord, I would like to start by the seriousness of this matter, that the second respondent, the fifth and the sixth, to show the unseriousness that they have, my Lord, they have not even taken before you as we speak. My Lord, to speak to the writ of habeas corpus in a case of Etrelita de Martinez versus Director General and others, that is in Philippines, and the case which was cited with approval in the case of Masood Salim Hamed and another versus the Director of Public Prosecutions, they defined habeas corpus as habeas corpus generally applies to all cases of illegal confinement or detention by which any person is deprived of his liberty or by which the rightful custody of any person is withheld from the person entitled thereto. In another case, this court said that the ultimate purpose of the writ of habeas corpus is to relieve a person from unlawful restraint. It is devised as a speedy relief from unlawful restraint, my Lord. And therefore, my Lord, this writ of habeas corpus is unlimited under Article 25, whatever the circumstance or whatever the situation. My Lord, as I conclude, the architects of our Constitution sought to address a historical concern. And the survivors of the Nyayo regime, my Lord, endured a very brutal police force that held them incommunicado without trial. And even during that time, my Lord, in the case of Karanja, who was detained without trial and later on murdered, was exhumed and the body was recovered for the families to see. So it means, my Lord, that even during the Nyayo era was better than the era that we have, because at the moment we cannot even get a body that we want. So it is my prayer, my Lord, that this court stamps its authority and help this nation secure justice. Thank you so much, my Lord.
The last word is stamp its authority and
the court to stamp its authority and help Kenyans get justice, because, my Lord, despite the fifth and the sixth respondents not being present in court now, we are patient to even wait for them in the afternoon, because yesterday, according to the presser that the DCI director issued, he said that he would be in court today. Thank you.
thank you. Mr. Mr. Mara, do you have a right of reply?
Yes, Your Lordship, I have a few.
What do you want to say?
Your Lordship, I want to begin first with the authority that my good friend Owino has just.
We are not discussing the authority here.
Yes, Your Lordship, but this is very critical, Your Lordship, so that we get to appreciate.
Everything is critical. To me, Mr. Mara, there is nothing more critical than when it comes to human life.
I agree, Your Lordship.
So let's not debate. Let's just be here.
Yes, Your Lordship.
And we are going to discuss about habeas corpus. We better understand Article 125C.
Yes, Your Lordship. I appreciate that.
It cannot be more clearer than that. So let's not go there.
Yes, Your Lordship.
Just address me what you wanted to say.
Yes, Your Lordship. In the same authority that Babu just read, Your Lordship, the judge, in that very authority, first authority, the judge said that it has been established the general burden in habeas corpus application must be pursuant to Section 107 of the Evidence Act and remains with the petitioner.
We have not gone there.
Yes, Your Lordship. The court said this is necessary for this court to appreciate.
Which court?
The High Court, Your Lordship, that the petitioner must establish any competent and convincing evidence that the missing person on whose behalf the petition or the application was filed is under the custody of the respondent. That is what is missing, Your Lordship, here. It has not been established that indeed the second petitioner is in the custody of the respondent. Your Lordship, my colleague Mr. Mangwa said that the delivery of this affidavit was not at the scene of the crime. Your Lordship, my colleague has been very selective in reading the affidavit that I filed. If you read paragraph 1, I believe Mr. Mangwa understands this, that I am a police officer in the meaning of chapter 84 of the laws of Kenya, one of the investigating officer in this matter. He has confirmed that indeed he is the investigating officer in this matter. A lot has been said regarding annexure number 1, that is the inventory, Your Lordship. The only person, Your Lordship, with the competency to address the authenticity of that particular annexure are my clients, because they are the author of that particular annexure. At paragraph, Your Lordship, paragraph,
The only person?
my clients, Your Lordship, they are the ones who came up with that inventory. So they are the only person who can
Mr.
speak
Mara,
to
your
them.
respondents,
Yes.
your clients include this, the Cabinet Secretary, the Attorney General.
Yes,
So who do you have in mind?
the second respondent. At paragraph 16, Your Lordship, the affidavit that my colleagues have been reading was contested in part.
Yes?
It reads that we've noticed that the copy of the inventory annexed to the affidavit of Lawrence Uturi has omitted the caretaker as having been a witness to the inventory. So we have not looked at that particular affidavit. The only annexure, Your Lordship, that we believe is the original and that was taken at the scene, the one that we attached. And this is annexure number 1. There is no application that has been made before this court calling the author of that.
So that inventory attached
cross-examination.
to the petitioner's affidavit is contested.
Yes, it's contested. And my colleagues, Your Lordship, are not expert in a certain.
Neither are you.
Yes, Your Lordship. That is true. So we can.
These are your colleagues.
Yes.
You are their colleagues. So none of you is competent.
That is true, Your Lordship.
That's better. Well
Yes.
put.
So